Hi, I'm Danica Haynes.
And I'm Courtney LeFevre.
And we co-authored a paper on the Foreign Corrupt Practices Act. The Foreign Corrupt Practices Act was enacted in 1977 following the Lockheed briberies and the Watergate scandal. The FCPA, or the Federal Corrupt Practices Act, prevents briberies of foreign officials and inaccurate accounting methods. And those are the two provisions in the law: the briberies and the accounting methods. As far as the anti-bribery provision goes, it's the tightest part of the provision because there's a lot of anti-bribery definitions and there's a lot of anti-bribery rules, whereas on the accounting side there's not that many. So the anti-bribery provisions say that bribing anybody who is a foreign official is illegal of anything of value. So they don't need to necessarily bribe people with cash. They could bribe people with anything of value. And even just having the knowledge of something going on would create the law breakage of the FCPA. Now, as far as who is considered a foreign official, that could be anybody from a foreign government, whether it be a professional working for a foreign government, or it's a political party or a candidate for a political position. Anybody who works in a foreign government could be considered a foreign official. Now, if there's anything of value that is bribed to these foreign officials, it's not in accordance to the FCPA. Therefore, if they were to bribe getting the foreign official's child a job or a golf trip or free college tuition, any of those could be considered anything of value. So just because it's not cash doesn't mean that it's not a bribe and considered illegal. If anybody has any knowledge of any wrongdoings on the FCPA, then that could be considered a law violation as well. So if you have any knowledge on potential bribery or inaccurate accounting methods, then you will not be in accordance of the FCPA law unless you come forward with that information. You can be prosecuted both civilly and criminally, and as far as the anti-bribery provision goes, the Securities and Exchange Commission would be the one to provide they would provide all of the trials for anybody who breaks the anti-bribery provision of the FCPA. Courtney is going to talk about the accounting part of the FCPA.
Alright, so with the accounting provision, it's less broad than the anti-bribery provision, and the basic idea is that companies are required to keep accurate and relevant books. So this whole idea of cooking the books kind of gets nipped in the bud right from the beginning. Another requirement of the accounting provision is to make sure that the company has internal controls, and this helps in preventing fraud or trying to cover up people's mistakes and any other illegal activity within the company. Now, just as Danica was saying, that the Securities and Exchange Commission goes after anti-bribery violations, the Department of Justice handles any accounting provision violations. And the different penalties can either be civil or they can be criminal. And if they're criminal, these usually include jail time. So it can be anywhere from a few months to a few years, and usually there's a really heavy fine involved, up to $2 million. And with the civil penalties, these are mostly just money, and they aren't usually as heavy as the criminal prosecution. But All of these penalties are to help us really crack down on bribery and accounting violations, and to help businesses to have an equal opportunity to really put themselves out there in the business world and make sure that nobody is trying to get ahead or get a leg up on the competition by doing anything illegal.